Alex here with part 48 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that is because my ex's parental rights have been terminated. Number two, the nutshell version as to the explanation of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off, not in the previous video, it was probably like 2 or 3 videos back, with an order from the court to the Secretary of State to participate in the lawsuit. And the lawsuit is the petition for judicial review that I had filed. And my mindset at the time was somewhat positive. I was concerned that the court, I was concerned that the government was just going to make me jump through a whole bunch of unnecessary hoops to tire me out. At the time, trying to get me to send a process server to Carson City felt unfair and expensive. And when I stuck it to the glass, I was pretty confident in my own understanding of logic and fairness, which are very dangerous approaches to take to the legal system. I have videos on these topics, for example, morality versus the law and fairness versus the law. Those are must-watch videos. But I had my understanding as far as those general overarching principles go that I was in the right, but I was a little anxious that the court wouldn't agree with me. I thought the court might take the government's side. Now, I did mention in that previous video that even if the court had done that, that might have actually done more harm than good to me, because trying to send me to Carson City, that's probably something that was unnecessary. But trying to get me to serve the Attorney General based on the statutes that I looked at, that actually is a requirement. And it could have backfired on me had I actually won this case, only to have the Secretary of State file an appeal and say that I didn't abide by the statute and therefore the court didn't have jurisdiction over the Secretary of State in this particular case, which I have a really bad feeling would have happened. Now, I didn't end up winning the case in the end, but that is something that I want to point out to my viewers, because even though something may occur that sort of buoys your confidence in your case or in the legal system, it doesn't necessarily mean that just because whatever it is that happened to make your outlook more positive isn't inconsistent with the law and potentially something that's going to backfire on you later on, which is what could have happened had I won this case. This specific petition for judicial review, I do eventually win this issue, but I end up having to refile this under another sort of approach, I guess you could say. This legal system calls it a vehicle, under a different vehicle. At that point, or at this point actually, everything having been said, we can actually go ahead and take a look at what I have filed. Here we have the appellant's opening brief. First thing I want to point out is the word appellant has 2 L's in it. Second thing is that I think I probably got this layout from a self-help forum. I don't think back in early 2010 that I knew the importance of reading statutes, rules, and case law and figuring out the format that way. And I did want to mention that the reason I say that is because this is the same exact sort of terminology that's used in an appeal, and the Nevada Rules of Appellate Procedure actually explain in detail how this works, and those rules actually include the requirements to have a table of contents and a table of cases. Typically, there will be more than just statutes in the table of cases, which is what I have in mind right there. There will typically be court rules in there and also case law, which I don't know why I didn't include any. Maybe I didn't cite any in this opening brief, and if I didn't cite any in the opening brief, that's not good. I probably should have done that, should have done some research on case law. But again, this is all way back in early 2010, and I probably didn't have a clue that any of that really mattered or even how it worked. So I'm going to scroll into this now. First paragraph we have that I identify myself, and I tell the court that I am representing myself, which is good. I'm starting to get into the pattern of doing this. I've been pretty intermittent about it prior to this point. Scrolling down, we've got the statement of issues. And the issues that I identify for the court are, number one, that a fictitious address is issued, and I put down the address of that fictitious address, to my ex, and number two, that it was issued on that specific date, September 21st. Second section, which is the case statement. This one starts off with me identifying myself as the father of our child. The second is, let's take a look here, that my ex has concealed herself effectively by using the fictitious address program. The third is that the fictitious address program is created for actual victims of DV. And the next section here is that in this case, it does more harm than good. Firstly, because I have not committed any acts of DV. And secondly, because my ex has before harmed herself and attempted suicide while he was only a year old and while she was present and he was present. I left that piece out there, but referenced this before in several of my other videos. In fact, you can actually watch the hearing video on it yourself if you take a look at part 8 of the My Docket series. I also mentioned that my ex was institutionalized at West Hills for a short period of time. Our next section here, we have, I'm just identifying that the fact that there may be other parents out there who are unable to or unwilling to defend their rights or the rights of their children, and that it's imperative that the Secretary of State is presented with clear and convincing evidence that a person is an actual victim before giving a fictitious address to an applicant. Going into the argument here, I cite a statute, and that statute is probably, let's take a look here. That is the one that confers the authority on the Secretary of State to issue these addresses in the first place. The second argument here is that the fictitious address has concealed the physical whereabouts of my son from me, and that I am aggrieved. The next, let's take a look here. Third one is, pursuant to a court order, the court stated that both of us are entitled to know where our child resides. It's better not to rely on a court's order in a situation like this because I'm trying to show where the authority comes from. And believe it or not, judges aren't authority. The only judges who are appellate judges, well, more specifically, judges with the ability to publish. Because they can publish an opinion and that will control everything else going forward in that state, or if it's the federal government in the country. And just an ordinary trial judge, they can make rulings, and those rulings are binding, but it doesn't mean that they constitute authority. You can't use them in another case to control the outcome of that case. What I should have used instead is used Rivero 2009, because that basically states what my judge is stating, which is that both parents are entitled to know where their children reside as a general rule. And let's see here, section 4, the eligibility of those who apply is outlined under the statute, specifically 217.462, where it's clearly stated that specific evidence showing that an adult child or incompetent person has been a victim of DV before the filing of the application. And this is where I'm able to sort of, this specific statute is the one that contradicts with the other statute that is the one that my ex's attorney used to get her the fictitious address. And that sort of contradiction is what leads to the Supreme Court taking action. Not in this case, but in the one that follows. Because as I mentioned earlier, this case is not, this approach is not the correct approach. I should have used a petition for writ of mandamus, not a petition for judicial review. It does matter. The Supreme Court, at least in Nevada, does care. And they do consider it a different legal vehicle, and they will rule against you if you don't use the correct legal vehicle. Let's see here. The subject was unable to prove that she was in any danger, and a far cry from it. She only proved that she was a danger to herself. Next line here is that the question of awarding a parent sole or joint physical custody states that, okay, what I'm doing here is explaining that it's really weird that there's a statute that forbids a person who has committed DV from having physical custody of a child, with some exceptions, and there's a rebuttable presumption and all that. But I'm pointing out to this court in this case that I do have physical custody of our son, and it's supposed to stand out to the court as absurd that I, a physical custodial parent, does not know where my son resides. The conclusion comes up next, and I am pointing out that the Secretary of State has failed to show any evidence, or should this court find that the Secretary of State has failed to show any evidence as required by the law, that this court should reverse the decision made by the Secretary of State, and this court should exercise its authority to order this judge to turn over my ex's address, her actual real address, which the court can do. There's a specific statute, and it's 217.464 subsection 2b, which allows a judge to order the confidential address program to turn a fictitious address, to turn over a program participant's real address to a person or entity. So I'm saying that I want this judge to order the confidential address program to turn my ex's address over to me. More importantly is that my ex's fictitious address is canceled, so I just don't have to deal with it anymore in the future. Here we have another statute that the Secretary of State needs to reimburse the county of Washoe. Oh, I know what this is. Okay, so there's two statutes that are coming into play here. This is really technical, and I don't know if there's even a point to really share it with my viewers, but I'll go ahead and do it because it's here. There is a statute that declares or entitles a person who prevails in what they call a special proceeding to an award of costs. And as far as I know, a petition for judicial review is a special proceeding. I might be wrong about that. I know for sure that a petition for writ of mandamus is. That's definitely a special proceeding. But I'm not 100% sure about a petition for judicial review. Anyway, if it is a special proceeding, then the prevailing party is entitled to costs as a matter of law. And there is another statute that comes into play here, and that's the one that contemplates fee waivers. And in this case, I got a fee waiver. I was able to proceed in forma pauperis, and that other statute states that if an in forma pauperis litigant prevails, then the in forma pauperis litigant, they don't get the money because they didn't actually pay any of the filing fees. They didn't pay any of the costs. But what is supposed to happen is that the losing party is supposed to turn that money over to the government instead. They're basically supposed to pay the costs into the court system that the forma pauperis litigant would have paid had their fees not been waived. It's actually very logical. It makes sense to me. It's basically saying, hey, you lost your case, you need to pay costs. Yeah, we waived the cost for this guy, but you still need to pay him. You just need to pay him to the government instead. Okay, we've got affidavit, which is, I think, sometimes called a verification, and this is in support of the opening brief itself. It specifically states that all of the factual allegations that I have alleged are under penalty of perjury. And the court rules and or statutes require this, in Nevada at least. I don't know why this thing says original, signed, and notarized. That makes me think that I printed the copies ahead of time and I went to a notary. And so then they stamped the original and just stamped the copies with this other stamp here. What I would recommend doing instead is to just take an original, get it stamped, and then run the original through the copy machine. That would be the better way, I think, to take care of something like this. I'm not sure if this is, allowed to just leave it blank like that and have it stamped, original, signed, and notarized, especially when this is the one that's been filed into the court. So the court system should have got the original. I don't know why they didn't get the original in the court system. Affirmation. This indicates to the clerk of the court that there's no social security number in this document. I've gone over this like 20 times, so I'm not going to go into any further detail into the affirmation. List of exhibits. Both of these exhibits I've already gone through in previous videos, and as with my previous policy of skipping over documents that I've already covered, I'm going to go ahead and skip over both of these exhibits now. The Reno police report you'll be able to take a look at in part 3 of the My Docket series. If it's not part 3, it's part 4, but I am mostly sure that it's part 3 of the My Docket series. The court order here that is mentioned, you can watch that if you go to part 32 of the My Docket series. And as with my previous videos, down in the description below, you will see a link to these documents, and you can go down and you can click on that link to download this document for yourself. And if you want to, at that point, you can on your own scroll down through the exhibits and take a look at them. But as I mentioned, I've already covered them in previous videos, and if you've been watching this series in order from beginning to now, then you'll actually already have these documents, or at least if you've been downloading all the previous documents, you will. Certificate of service. The certificate of service by mailing. This is a service under Rule 5, which allows you to serve an opponent by mail. And that's basically what I did, and I'm certifying that for the court now. I took this opening brief, stuffed it in an envelope, and mailed it to Wayne Howell, the Solicitor General. I don't know why it says Assistant Attorney General. Maybe that's what he's got. Maybe he's got 2 titles. I know for sure that I've seen him referred to as the Solicitor General. And we've got another affirmation. Each document basically, or at least at the time, had to have one of these affirmations. I'm not 100% sure if this is still required. I think it is, but I'm not 100% sure. Notice of change of responsible attorney. This is actually the document that they filed to substitute this guy in. This Wayne Howell guy didn't originally start off as the representative or as the attorney for the Secretary of State. Originally, it was a guy named, I think it was New Nguyen. Let's take a look down here. Ross Miller, who is the Secretary of State, buying through his attorney, Catherine Cortez Masto, who is the Attorney General, is basically substituting out New Nguyen, I think I got it right, for Wayne Howell. And this document is one of the documents that the Attorney General uses to swap out attorneys in the middle of a case, which is what they're doing here. I don't know why they're doing it. Maybe New Nguyen was too busy. Maybe he had other work to do. Maybe they thought this was a case that was too complicated for him, and they thought maybe Wayne Howell would do a better job. I don't want to speculate. I have no idea as to why they decided to substitute this guy out, but they did happen to do that, and this is the point at which they happen to do it. Catherine Cortez Masto signs it herself? No, it's Wayne Howell signing it. Okay. Wayne Howell, Solicitor General, signs this notice, and he indicates that he had it mailed to me at this really, really old address. Going into the aftermath, I filed 2 documents. They were both free filings, so I incurred $0 in costs. The government filed 1 document, that's the notice of change of attorney, and they therefore incurred also $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government's attorney was swapped out. However, I mean, it's a Solicitor General. I'm just going to assume it's another, $250. I'm going to try to keep the attorney fees portion of the series as simple as possible. I'm not trying to get it very scientific or very accurate. I'm just trying to give my viewers a sort of ballpark as to what's going into each party's attorney fees. And even then, I'm trying to err on the conservative end because I don't really want to be portrayed as somebody who's trying to embellish the amount of attorney fees that other people are paying as, they go up against me. And by the way, it's very likely that it's a whole lot more than I'm indicating, but I just don't know. And since I don't know and I'm having to estimate, I'm doing the best I can with the knowledge that I have as far as how much time I think goes into these documents, and also with erring on the conservative end, with trying to keep them so that they're, if anything, I'm underestimating, not overestimating. So for the Attorney General to prepare a notice of change of attorney, that's probably like a 5-minute document, if that, maybe. I think 5 minutes probably is pretty reasonable, because they would have to coordinate between each other, at least briefly, maybe even just by email, to say something like, hey, I need you to take this case over. To prepare the document is probably just one of those form documents that they just backspace out both names, replace them, and that's it. The certificate of service that I filed, I'm going to just say negligible amount of time, maybe not even, let's just say 0 minutes for something like that. And the appellant's opening brief, they would have probably put some amount of time into that. I'm going to go ahead and say 25 minutes, and the only reason it's low is because it's short. I don't go into any case law at all. They're just going to have to look at the gist of my argument, and that's it. They're probably going to put a whole lot more time into their answering brief than they are going to put into reviewing my opening brief. So 25 minutes with the 5 minutes for the notice of change is going to come to 30 minutes, which is going to be a total of $125 in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.